Thank you, everyone, for being here. Always really good to see you. Someday it's going to be in person. I am really grateful not only to the Business Council, but especially to Frank Kerbein, who is the Director of Center for Human Resources with the Business Council. He has been such an incredible and invaluable resource for us over this past year and a half. So I am delighted to introduce him. And Frank, maybe some good news. Or not.
Good news. That'll be the challenge. Yeah, it's the crazy season in Albany. The New York State budget is due on April 1st, and we have a lot of outside challenges taking place in Albany. If you read the papers, and it's a crazy time. And throw COVID on top of that, and the year we've had, it's remarkable that. And we appreciate the efforts all you guys have done in keeping your company's heads above water. I've been asked to talk a little bit about some of the changes regarding leave that are out there, vaccine leave and paid COVID paid sick leave, and the new changes to the American Rescue Plan and the changes that'll bring, and a little bit about vaccines. Can we require it? What should we do? What should we be worried about? Vaccines. So I'll do that. I'm going to share my screen because I got to have a PowerPoint, right? And right away you'll be alarmed to see there's 48 slides in this, but we're not going to do them all. It's impossible to get through that many things, but I wanted to always provide you guys information. So I'll send these slides to Denise and everyone so you can have them. There's a lot of information on there. I'll go through them quickly though today. What's become clear is that both the state and federal government have come to the conclusion that employees impacted by COVID have their income at risk, and that employers should bear the burden of replacing that income when someone is impacted by COVID. So employers are going to be, let's approach it from this perspective. If with every case we have with our employee, it's more likely you're going to have to pay them than not, right? So the questions I usually get are, so-and-so is mother's, sister's quarantine, do I have to pay it? Let's just start from the premise that most likely we will have to, and it's going to come out of your pocket. But we'll talk specifically about what's going on out there now. As usual, I'm not a lawyer or a tax person. I'm going to be talking about the tax code through this, and you'll be wanting to check with your own legal counsel on these things. So we have New York State COVID paid sick leave. And remember, we can only use that for one reason, sort of. And that is if you're quarantined by a public health official. Depending on the size of your organization, you either provide 5 or 14 days. If you provide 5 days, if you have less than 100 employees, then your DBL PFL carrier picks up the rest of that. If you have more than 100 employees, you're paying the full cost of a 14-day quarantine. Remember, when this was passed in 2020, we were all going to be sick for 14 days, and we're back to work, right? Things change, and science has changed, and people are quarantined more than once. We'll talk about that more in a second. And this paid sick leave is out of your pocket. It's from the employer, paid to the employee in addition to any other paid sick leave benefits you have. There's not reimbursable by any government agency for you. We have recently passed New York vaccine leave on top of that. I'll talk about that in a second. And then we have the Ffcra leave. We've been calling it that for a year. It's still referred to as that, but what it's really become is a tax credit system. The mandatory aspects of providing FFCR leave are gone. That expired in December 31st, so you're not obligated to provide emergency paid sick leave or emergency paid family leave. However, if you choose to do so, 100% of the cost of the benefits you provide are reimbursable to you through the withholding system. Before you submit your 941 on a quarterly basis, you get to keep that money off the top before you send it to the IRS. The American Rescue Plan made some changes to this. We'll talk about those in a second. But let's think about that as more of a, it's voluntary now. You can voluntarily participate through the end of September, but it's a tax system to determine how we can get reimbursed for the leave we're providing from New York State. And then we have New York State's paid sick leave law, which we've talked about here in this program as well. So what are the changes to the FFCRA paid sick leave as a result of the American Rescue Plan Act, ARPA? For some reason, I'm uncomfortable calling it that. I'm going to call it American Rescue Plan. Um, if you remember, it was available for 5 reasons. They have now added a sixth. It's number 4 here, and that is obtaining immunization or vaccination related to COVID, or if the employee suffers side effects from the vaccine, time to recover from any injury, illness, disability, or condition related to such vaccination. So there were really 6 reasons now that an employee could take leave and you could be reimbursed for it under the Ffcra. If they're quarantined by a public health official, number 1. If they're advised by their healthcare provider to stay home because of underlying health conditions. I have COPD, and we've had a positive employee in my office. I wasn't close to him. I didn't have a close or proximate exposure, so I'm not quarantined, but I'm just nervous. My doctor says stay home for 14 days. That person could be eligible for leave, and you could be reimbursed for it. If I'm experiencing symptoms myself, seeking medical diagnosis, and now if I'm obtaining immunization, and the time to do that, and if there's any side effects. In addition, I can still get leave for if I'm caring for someone else in my family. So if my mother-in-law, who is a cancer survivor, needs me to take care of her because she has an exposure to COVID, I could take leave and you would get reimbursed for that as my employer. And then finally, caring for an employee's child if the school or place of daycare is closed because of the pandemic, that qualifies for emergency paid sick leave as well. Remember, these benefits only apply to employers of less than 500. You are allowed up to 80 hours of this paid sick leave. Now, this was passed back in April. It was effective April 1st, 2020. And when that was passed, you only get reimbursed 80 hours per employee one time. So if I was quarantined last September, 80 hours, I took the 80 hours leave, you submitted for reimbursement through the Ffcra. That was it, one and done for me. The American Rescue Plan has now said on April 1st of 2021, 2 weeks from now, if an employer is voluntarily participating, they can reset the year and offer me another 80 hours of Ffcra and get reimbursed for that, right? So that is one of the changes from the American Rescue Plan. If I'm caring for myself, if I'm doing reason 1 through 4, I'm entitled to 100% of my pay up to a maximum of $511 a day. 10 days is $5,110 total. If I'm caring for someone else, my mother-in-law or my child whose school is closed, I get 2/3 of my pay for 10 days up to $2,000 total. It provided an exception for healthcare providers and emergency responders, but that's gone now, right? This is voluntary for everybody. It doesn't carry over the following year. And now the tax credits are available through the end of September of this year, 9/31/21. If it's extended beyond that, we don't know. It's been extended 3 times now, but at this point, through 9/31/21, this will end. For FMLA, this was the more complicated one because this caught a bunch of employers who weren't typically caught in the FMLA net. Typically, the Family Medical Leave Act applies to employers of 50 or more, and it provides 12 weeks of unpaid leave to care for themselves with a serious health condition or a family member who has a serious health condition, bond with a new child, things like that. The Ffcra changed that to apply to all employers of less than 500 employees. So we had a lot of employers who never had to deal with FMLA language who were dealing with it now. It was available for one reason and one reason only. That was for an employee to take FMLA leave if their child's school is closed due to a pandemic, or first bullet. That's been changed. Now it's available for any of the reasons listed for emergency paid sick leave. Okay, so it's been dramatically expanded. Again, only applies to those with less than 500 employees. It used to be the first 10 days of this FMLA, this paid FMLA was unpaid. Now it is paid. You are eligible for 2/3 of your rate of pay at $200 per day. So the cap used to be 10 grand, now it's 12,000, and it's now 12 weeks total. So if you think about it, you could have someone who is isolated by their healthcare provider because of a serious health condition. I have COPD, I'm receiving cancer treatments. It's not safe for me to go to the workplace. Who could, if you are voluntarily participating, get up to 12 weeks of job protected leave at 2/3 of their pay, $200 a day. Now, the question I get asked a lot is, well, should I voluntarily participate in the paid sick leave program? I kind of think you should, because as you're going to see, New York State requires we do it anyway. And you get paid for 80 hours of it, for 10 days of it. You get reimbursed and helps the bottom line of your company. I don't know a lot of people who have opted out of the emergency paid sick leave provisions of the Ffcra. However, I have seen a lot of people opt out of the emergency Fmla under the Ffcra. A lot of acronyms going on here, I know. And that's because 12 weeks is a lot of time, right? If I have a limited staff, limited number of people, you know, I don't want to necessarily encourage everybody to take 3 months off at 2/3 of their pay. I need them there to work. We've seen this with some daycare facilities, you know, that have teacher-student ratios that just can't accommodate losing so many people for this reason. So they have stopped voluntarily providing emergency Fmla under the Ffcra. Doesn't matter if you get reimbursed for it if you can't be open because you're short of staff. So again, those are some of the considerations you'll have to make as an organization to determine whether you want to voluntarily participate in these benefits or not. Again, there were some exceptions for healthcare providers. Those are gone because it's voluntary for everybody. The same with small employees. Again, you're reimbursed through the withholding process. You withhold taxes, wages, and payroll taxes, and you submit those to the IRS before you submit your 941. You can keep those monies beforehand. Check with your payroll company. They've become very good at Ffcra reimbursement. There were some changes as part of the American Rescue Plan that, for example, if you made pension payments to a union pension plan, you can get some of those back now as well. So there are significant tax credits available if you voluntarily participate. But again, that's going to be your decision as an organization. New York State COVID paid sick leave, again, is available for one reason, as that is if you are quarantined by the state of New York, Department of Health, local board of health, any government entity. This is a public health official. They will get it's an email that says they've been quarantined from this day to that day. When that is provided by the employee, they are entitled to paid sick leaves benefits under New York State's COVID paid sick leave. Typically, if you have less than 100 employees, you're paying 5 paid days of sick leave. This is out of your pocket, no reimbursement from this. That's above and beyond what you already offer for any other benefit, including New York's own paid sick leave law that just went into effect. 5 bonus extra days. And then the employee can apply to the PFL DBL carrier to get the rest of their quarantine period paid up to 100% of their pay, up to $150,000 a year annualized. If you have more than 100 employees, you have to provide this. You have to provide 14 days. You're paying the whole cost. 14 days of the cost of the quarantine. There's no DBL or PFL benefit for your employees under this provision. And again, it's up to. We're seeing a lot, and that's 14 calendar days. We're seeing a lot of guidance has changed. We have individuals who are quarantined for 7 days, 10 days, depending on the extent of and type of exposure they had. You're not required to pay 14. It's the time that during that 14 calendar day period that they would have been working per their quarantine document that you're eligible to pay them. There's an example here of how the DBL and PFL work together, but that's really your carrier's calculation. You would make sure your employees get the PFL DBL form from the state's website. There's a special PFL form for this. And then this is a claim between your employee and the carrier. And we're kind of out of it. Benefits aren't available to employees who are asymptomatic and can work. So if I get quarantined because I had exposure to someone with COVID, the contact tracers track me down and quarantine me for 10 days. I have the ability to work from home. I'm asymptomatic. I'm not sick. I can work from home. I'm not entitled to any of these benefits. And again, this leave is provided without loss of the employee's own paid time off programs. This is above and beyond what you already offer your employees. And again, if you travel to a non-contiguous state voluntarily and you come back to the workplace, there is a quarantine in effect. It's only in effect till April 1st. So we only have to worry about this for another couple of weeks. Those people quarantined, that would be considered a quarantine by a public health official. However, there's a special provision that says they are not entitled to COVID paid sick leave if they voluntarily go to one of those other states. I pick up and decide I want to go to Florida for vacation, spring break in March. I come back, I'm quarantined. I can't test out, or I don't test out for whatever reason of quarantine. my employer is not obligated to provide these benefits to me because I did that voluntarily. This is, I know there's a lot of text on here. I'll just summarize it for you. On January 20th, the Commissioner of Labor put out some guidance regarding COVID paid sick leave in New York State. The Commissioner obviously works for the governor, so this comes from the executive branch of New York State government. And the short version here is that it now allows employees to get 3 cracks at the New York State COVID paid sick leave. If you read the statute, the legislation that was passed and signed by the governor, it doesn't say that. It says you get 5 days or 14 days. The Commissioner of Labor has now expanded that to be 3 cracks at the benefit. So if I was quarantined last August because my wife had COVID and I was a close contact, I was quarantined, you paid me my 5 days, I got PFL for the remainder of my quarantine period. That's all great. Now today I get quarantined because I test positive for COVID. I am entitled to another 5 days from you and another crack at the PFL DBL benefit. And then again, a third time if I were to test positive. So I get 3 chances to get this benefit from you. It's possible you could pay an additional 15 days paid off to your employees. If you're a large employer, you have over 100 employees, that's 14 times 3, that's 42 extra days of COVID paid sick leave benefits above and beyond any other leave time you provide. I have some things underlined because to me it's interesting what the commissioner put out. We think it goes beyond which he's able to do by law, but we don't have standing to sue. One of you guys would have to sue, and I'm sure it's going to happen, but it's in the short term, this is what we're dealing with. It says employees do not need to be tested before returning to work. That's fine, but I know we have some employers who've adopted a policy of requiring a negative test after I've been quarantined. So if I got quarantined in January, had COVID, after 14 days, I'm released by the county Department of Health and they say I can come back to work. We've had some employers say, I don't want you to come back to work until you've got a negative test. Here's the commissioner saying you do not need to be tested before returning to work. And this is important for a reason I'll mention in a second. Because if you test positive, you must not report to work. Second paragraph. Anyone who continues to test positive must not report to work. I'll mention that in a second, why that's important. Please note that an employee is not recommended to be tested to discontinue isolation or quarantine. So the departments of health are releasing people from quarantine without testing them. Doctors are returning people to work because they're symptom free or whatever, without having subsequent testing. I thought this was concerning. I thought the commissioner was sort of getting into public health there and providing this guidance. I don't know how this was designed to, slow the spread and all that, but this was in her guidance. The third bullet here is that you're limited to 3 periods, 3 orders of quarantine or isolation. So you only get the benefit 3 times as of today. As I mentioned, there's no mention of it in the statute. So she picked 3 as a random number. I guess you could pick 5 later in the year, but we'll worry about that when we get there. But the most concerning paragraph was this. This is entirely not in the statute, but this is now in effect as guidance, which carries the effect of law for the commissioner. If an employer mandates that an employee who is not otherwise subject to a mandatory precautionary order of quarantine to remain out of work due to exposure or potential exposure to COVID-19, regardless of whether such exposure or potential exposure was in the workplace, the employer shall continue to pay the employee at the employee's regular rate of pay. That means if we have a policy, like in the first bullet, where you have to test negative before you return to work, we're getting anecdotal evidence that someone who has test positive for COVID can continue to test positive for COVID for up to 3 months after they've been cleared to return to work. They're not asymptomatic, they're not shedding the disease, so to speak, but they're still going to show up as testing as positive. According to the commissioner, if we kept them out of work pending a negative test, we are required to pay them for the extent of that absence. So this was a concerning part of it. They call it a lockout. When you talk to the governor's office, so we do, we get a hold of the commissioner's office, the governor's office, and we say, well, this seems like it's extra legal, that it's goes way beyond the intent of the statute. The response is always, well, if an employer is going to lock out their employees, they should have to pay them. So that's their perspective on this. So, and that's where I was going to at the top of this presentation, that it's clear that the state and the federal government both are putting burden on employers to bear the cost of employees impacted by COVID. So we're going to see unfortunately, or I'm not a public health person, so I don't know, but we're going to have employers welcoming people back to work without testing before returning to work, for fear that they do test positive and have to stay out of work. So we're concerned about how this will impact on slowing and stopping the spread of the virus. But again, the commissioner is not a doctor; she's a commissioner of labor. So that's the major change with New York State's paid sick leave guidance. So when we're looking at New York State's paid sick leave, well, great, now I have to do this 3 times. Maybe I need to reconsider my voluntary participation in the Ffcra because I can get some relief from this. I can get reimbursed for some of the absences my employees have for these multiple incidents of absence from work. And then put on top of this another mandate for time off, paid time off for vaccines. The governor had put this in his budget proposal, which typically passes April 1st. But that is moot now because the legislature moved on their own to pass this bill in a hurry. They did it in about a week, and the governor signed it this past weekend. So it's effective now, and it requires all private and most public employers to provide a paid leave of absence for a sufficient period not to exceed 4 hours per vaccine injection. So we have to provide a leave of absence to employees who get their vaccine, and we have to pay them for that time up to 4 hours per vaccine. Shall be provided at the employee's regular rate of pay. Regular rate of pay is always a disputed term. It has a specific meaning under the Fair Labor Standards Act. The New York legislature throws it in willy-nilly. Sometimes they say regular, sometimes they say normal. But in this case, it says regular. Elsewhere in the labor law, in Article 6, where this appears, there's the definition of wages that says it includes all supplements. So I would argue that if you have an employee who's getting paid, as, for example, prevailing wage on a construction project, they're going to have supplements added to that. If you're going to pay them what they would have been paid that day, including supplements. If you have someone who gets a shift differential, they make $15 an hour during the day, but they make 16 when they work the second shift, and they call in on a second shift, or they get their vaccine on a second shift, you're going to pay them $16 an hour. It shall not be charged against any other leave program. So again, this is above and beyond what you already offer. They mentioned specifically the paid sick leave. You can't charge it to that. Our argument was we just gave everybody 40 or 56 hours of paid sick leave. Do we have to provide them this? Yes, you do. This is in addition to that. It's not reimbursable to you by any tax credits either. It's unlawful to discharge, threaten, penalize, or any other way discriminate against employees for exercising their right under this. There's no prior notification requirement. So I think with the nature of vaccines, we're all learning that I could get an appointment for April 15th, but then I check the site today and it's available tomorrow. I sign up and I go get it tomorrow. I think we're going to have to accommodate that and pay that person for that without really any advance notice. Paid family leave, the new paid sick leave law all talks about leave as soon as practicable. I'm sure the DOL will be applying the soon as practicable standard here as well. It won't require any long-term notification period. Can I require proof that they got the vaccine? We can. The statute is silent on this, but the EEOC has said that we can ask about an employee's vaccination status, and we should. If an employee says they're taking time off to do this, we should get proof that they did. And remember, if we get some proof, then we can submit it to the Ffcra paid sick leave, right? Because this is now a covered reason to use Ffcra credits to get reimbursed for that. So we have a couple of reasons, justified reasons to ask for proof of vaccine. One, we want to know you did it. And two, we want to submit it to the IRS for reimbursement under the Ffcra. The key phrase here, it's unlawful to discharge, threaten, penalize, etc., intimidate, discriminate, retaliate. If an employee says, I can't find it, I don't know where it went, there'll be a degree to which harassing them for that will cross into discrimination. So you'll want to be careful of that. Same with if they have no prior notification. Hey, boss, I just got my vaccine changed to tomorrow morning. I won't be in the morning. You can't do this to me. I need you in the morning. If you do this, you're fired. I would argue that is threatening, penalizing an employee for exercising their rights under the statute. So let's keep our cool when employees say they need time off for vaccines with very short notice. Any Any questions on any of the changes to the leave policies before we get into vaccine stuff? Okay. Then I'm going to skip a bunch of slides. This is about New York's paid sick leave program. We've been through that before, I know. Here's how some of these leave programs interact with the Americans with Disabilities Act, Human Rights Law, Fmla, paid family leave. If you have 15 or more employees, you're covered by the ADA. If you have more than one employee, you're covered by New York State Human Rights Law. Both those laws require that employers provide reasonable accommodation to individuals with disability. Leave is a reasonable accommodation, right? In a lot of cases, it's an accommodation. So what we're having now is employees exhausting their mandated benefits, right? You had to offer me 40 or 56 hours of paid sick leave. That's job protected leave, so you can't fire me during that leave. But now here it is March, and I'm already using my 7th or 8th day. You're mad, you want to fire them. I warn all employers that what you have to do is remember that you're covered by human rights law and the Americans with Disabilities Act. So we have to bring this employee in. We can't presume a disability. We can't say, hey, look, I see you're in a wheelchair. How are you going to do this job, right? So we have to ask this employee, you're about to have some job action taken against you because of your attendance. Is there anything we need to know before we take this job action? Oftentimes we get employees at that point say, well, you know, I feel bad. I've been suffering from depression, and my doctor gave me this medication that makes it hard for me to get up in the morning, and that's made it difficult to get to work. That is an individual who has just now identified themselves as disabled under the human rights law and the ADA, and has asked for an accommodation. They've asked you to provide a change in their schedule, at least. Maybe they're asking for leave, okay? Now we're engaged in what we call the interactive process, where we discuss this. We try to find out what exactly the limitations are. We're entitled to medical documentation from their physician to explain exactly what their limitations are, what kind of leave they have, and then we determine whether that's a reasonable request or not. So the point of that story is that once someone exhausts their state mandated leave, it's not open season on getting rid of people, right? We still have an obligation under other laws to make sure that we're listening for accommodation. And again, the request for accommodation doesn't have to have them say, I want accommodation under the ADA. We have to listen to family members, right? Sometimes we call and say, where's John? We haven't seen him in 3 days. Oh, he's been sick. He's been getting this treatment. He has a new medication he's on. I'll have him call you. We have to assume that's a request for an accommodation from that individual, okay, even when it comes from a family member. So that's, again, just I tell that story as a sort of a warning that we have this job protected leave we have to provide. We can't threaten, intimidate, retaliate people for exercising their rights under that. And then, even then, when they have exhausted all their protections, we still have to be careful before we take any adverse job action. This goes on to explain exactly what disabilities and reasonable accommodation is. Same with the Family and Medical Leave Act. Vaccines. So the question I get asked most frequently is, well, sometimes it's a state, we're going to require all our employees to get vaccines before they come back to the office. That's permissible. There is a precedent for requiring vaccines. There are certain healthcare workers who have vaccination requirements for the flu vaccine. However, this vaccine has a special status. It's been approved for emergency use authorization only. You hear that a lot. It's EUA, emergency use authorization for the Pfizer, all the COVID vaccines. The flu vaccines typically have the full approval of the FDA. This has sort of a conditional approval of the FDA. And from a fairness requirement, I think obviously we've seen in polls and feedback, there are people who are hesitant to get a vaccine that was generated so quickly and approved so quickly, and approved only for emergency use authorization. Still, you could require vaccines as condition of employment. There is some EEOC guidance on this that's very helpful. This slide discusses EUA, emergency use authorization. The reason the state of New York or any public any government hasn't required the vaccine of its citizens is because of this EUA. Should this EUA go away, I bet we start to see municipalities and governments mandate the coronavirus vaccine. We have to be aware that, again, individuals may object to the vaccine for health reasons. I have an underlying health condition that makes the vaccine more threatening to me. If anybody's had the vaccine, you know there are screening questions that they ask you before you get the vaccine that reveal information. So the question typically is, when the vaccines become available, I want to have someone come into my office and I want to administer the vaccine to all my employees here in the office. There are risks to employers for doing that, and the risk is that you become aware of information from your employees that you don't need to know, that you don't have genetic identification information, that you don't have, my family has a history of this particular disease. You now have something that has provided this employee protection under the Americans with Disabilities Act. So yes, you can require the vaccine, but there are great risks to doing so. And those risks come with revelation of personal health information that you don't need to know, right? You're gonna have employees say, I can't get it. Why? Well, if you ask why, you're now asking information that the EEOC prohibits you from asking, right? Because I'm not obligated to tell you that I have an underlying or genetic information that prevents me from getting the disease. There are also going to be religious accommodations. People who are going to oppose the vaccine on religious grounds, and they have to be accommodated as well. So what we're seeing is most employers are encouraging and incenting employees to get the vaccine. It used to be that I'll pay you for the time to go get the vaccine, but now that's required by law, right? So they're coming up with other incentives to try to get employees to get vaccinated. We are allowed to ask if they have had the vaccine. So the EEOC has made that clear that by asking merely yes or no, if you had the vaccine, we are not violating any undue or untoward medical inquiries as an employer. So it's out there, you can require it, but the risks are pretty severe. Most employers, as I mentioned, are merely incenting their employees to get the vaccine. Any questions? And then I have this goes on to talk about how the ADA protects from inquiries. The EEOC has some guidance on this. If you're going to required, you may have to show job related and consistent with business necessity. You're going to have to provide accommodations to individuals who have health conditions and with religious exemptions. So the employers typically do nothing, let the vaccinations occur naturally as employees go get them. And in fact, you can't set up an employer-based clinic right now for vaccines. There just aren't enough vaccines to do that. Encourage and or incentivize voluntary vaccination. You can require proof of vaccination as a condition of employment, but you're going to have the same issues with the objections related to underlying health conditions, ADA objections, or religious exemptions. If you're going to require a vaccine, don't do it yourself. Again, that goes to the fact that we don't want to know the information we have to gather during the pre-vaccination queries, right? We have to ask them if they have allergies and do they have any history of this or blood clots or any of those other things. And the employer should never be asking those questions. If you are going to do it, let's have a third party do that on our behalf for us. So if you have a bunch of forward public-facing employees, you might want to require that to protect them and to protect exposure of your customers and the public, general public, from getting the virus. That would be probably the only group I would think considering and making it mandatory. But approach this carefully as you do this. Once the employee use authorization goes away, we're going to have more flexibility as an employer to do more regarding requirements. Any questions on any of that?
I think there are a couple questions.
All right.
The first one is COVID leave incremental to PTO?
Not quite sure I follow, but COVID leave is above and beyond any PTO you offer as an employer. So I don't know if that answers your question, but you could provide, unlimited PTO. No, let's not do that. You offer 100 hours of PTO to your employees. If they go get the vaccine, they're going to use 4 hours. That does not come out of their 100-hour bank.
Okay. All right. And then, thank you. One other question is, if employers do incentivize employees for getting the vaccine, can someone who's not medically able to be vaccinated bring a discrimination complaint against the employer because they're ineligible for the incentive?
Good question. And the answer is yes. And that's why the incentives need to be, we're not going to give out $1,000 to everybody to get a vaccine. Maybe we give them a coffee mug or a t-shirt, some de minimis type of incentive to those employees, because the greater the incentive, the greater the chances of a claim of discrimination based on my underlying medical condition or my religious objections. And if I was handing out t-shirts to everybody who got the vaccine, and an individual came to me with a religious objection and said, that's not fair, everybody gets a t-shirt from me, I'd give them a t-shirt.
Okay.
But yeah, there is a risk of that. So that's why we want incentives to be of a reasonable amount. Anything else? Like I said, I'll give you all these slides. There's a lot more detail on these slides, of course. I just didn't want to take up your time with stuff that we've already covered in the past on other paid sick leave benefits.
Any questions for Frank?
Frank,
Cool.
I have a question. It's on and off the subject. My understanding is the legislature has introduced a bill requiring employers to protect employees from communicable diseases. Can you give me an idea how likely that is to be passed?
Oh yeah, it's one of those things that's on our radar. It's a big problem. It has passed the Senate. It is going through the Assembly committee process now. It's a requirement that all employers of 10 employees or more adopt a plan that will be written by the Commissioner of Labor that will mitigate airborne infectious disease. So it's not limited to COVID. It's limited to any airborne infectious disease. I would think the common cold or the flu would be included in that. Employers would have to adopt this plan. It's very specific in the bill what's in the plan: social distancing, masking, PPE, all the stuff we're doing now. There's another portion of that plan that requires these employers, again, of 10 or more, to permit employee-employer workplace safety committees. And it tells you exactly who has to be on the committee, its makeup regarding supervisory and non-supervisory employees, the duties of the committee, their ability to review the plan, to make changes to the plan, to go get paid training so they can be qualified members of the committee. This bill we think is very troublesome. The Senate doesn't care. It's called the HEROES Act, right? So how can you vote against the HEROES Act? But essentially all the provisions that they talk about are already in effect now. OSHA requires you to maintain a workplace free from hazards, including infectious disease, and it has several standards. Standards is how OSHA enforces these laws, through the respiratory standard, through the bloodborne pathogen standard. There's a lot of things in place. There's a TB standard. So there are already protections in place that employers have to do. If they know there's an airborne infectious disease like COVID, they have to, under law currently, protect their employees from that. This goes farther. It puts New York State, the Department of Labor, in charge of this. To complicate things, on January 21st, President Biden signed an executive order directing that OSHA develop, if they felt it was necessary, to develop new standard regarding COVID in the workplace. It had to be done by March 15th, which is this past Monday. OSHA didn't do anything publicly, though our sources tell us that OSHA has developed an emergency temporary standard. By law, what happens when they develop that, it has to go to the Office of Management and Budget to get cost, see how much it's going to cost employers to implement. And then it'll be promulgated. We have sources at OMB who told us this is being done. It does similar things to the HEROES Act. It requires employers of 10 or more to adopt a written plan. They're focused only on COVID, so it wouldn't apply to flu and other airborne diseases. It does not require the Labor Management Committee, which we think is a win, but it does require anyone who has an exposure to COVID in the workplace to be allowed to go home and the employer will pay them. And from what we hear, there's no limitation on that. Again, we keep the employee away, we pay them because of their exposure in the workplace. So this is a very active area. If the assembly, we got the assembly to stop, to slow down, pending OSHA's March 15th deadline, right? We said, don't do anything yet. OSHA might come out. It might be exactly what you're trying to do. OSHA is behind schedule, you know, and I guess you can't expect your government to work on time all the time. So they're a little behind schedule. So it's a matter now of trying to put the brakes on the assembly from going forward with this bill. If this passes, it'll be signed into law, and it'll be the law in New York State, and it'll be a significant new burden on employers, especially small employers. 10 or more is a small number to have an employee management safety committee and provide training and have a written plan and a binder that gets reviewed on a regular basis. That's a lot. So we think it's a pretty significant bill. We're hoping we can slow it down or stop it pending what OSHA does. You know, if OSHA promulgates a new standard and it's objectionable to employers, we have employers of the whole country come to bear to put pressure on OSHA not to adopt the rule. New York State, there's also the risk that New York does it anyway, even if the standard is promulgated and they do this. They like to do this just to sort of send a signal, you know, that they're doing something to protect workers, even though they know federal law will preempt this. So that is an excellent question. It's a hot topic. And we'll see within the next couple of weeks what happens with that.
Okay, thanks, Frank.
Sure.
Frank, I have a question, Shelley Sillop. With all the new regulations with regards to paid sick time and COVID, should that be built into our employee handbook?
You know, I get that question a lot and have for the last year. I think the problem with that is it changes so frequently. And, you know, handbooks are a pain in the neck to update, right? We don't like to do it once a year, much less every couple of months, as we've had to do it since March of 2020. I think it's, and you can also, I don't think you could write a policy that would capture every potentiality. I mean, there's so many strange things that could happen that, boy, that you start writing that policy, you'd have a 10-page policy, right? So I think it's good to, when required, put up the posters. There was a poster for the Ffcra that I think probably still should be up if you are participating in that. Communicate with employees on a regular basis. You know, these are employees who are impacted by COVID, so you should know who they are, right? They're not coming in because you've caught them through your daily screening process, or they've self-identified as being impacted by COVID. So I guess my feeling is you could put it in a handbook, but boy, you'd be doing handbook updates all the time.
Thank you.
Frank, this is Jeremy. I've got a question back with the Ffcra. So did I hear you say that the emergency FMLA, that is separate and that we don't have to offer both the sick leave and the EMFLA?
Right. We're seeing employers choose one or the other for the reasons I mentioned. Some can't go without the staff under the FMLA.
Okay.
As this is all now voluntary, as of December 31st, this is voluntary. So the thinking is that you can offer one or both. You don't have to offer both. They're not dependent upon each other.
Okay. Have you heard, so what I'm reading on a lot of these HR sites is, and I think that there might be some confusion on it, is it an option to, if we do decide to go with the paid sick leave and the resetting of the 80 hours, is that optional too? I mean, if somebody's already used it, do we have to reset it for everybody?
No, that's correct. It is optional. It's optional. Now, there are provisions in the new American Rescue Plan about discrimination and how we apply the benefit. They're hoping that we don't apply this to highly compensated employees and not to others.
Okay.
So I'd be careful in that regard. that I reset for some others and not for some employees. I reset for my directors and VPs, but I didn't reset for my rank and file workers. But no, the option to reset is just that, it's an option.
Great, thank you.
And we still, the department is going to put out guidance. You probably have all seen the Ffcra Q&A that was put out by the Department of Labor. They're up to 105 questions or something now. We will certainly get more guidance from the department as this goes on. But that's where we're at now. It's a week old today, the law, so.
Any other questions for Frank?
My contact information's on the screen, so you guys can reach out anytime with any questions you have. Again, I'll get these slides to Denise, and she can distribute them however she wants. And you have trouble falling asleep some night, you can pull them out and read. Get way into the weeds on this stuff.
Ooh, sounds like an exciting weekend.
There you go. Welcome to my world.
All right, if there aren't any more questions, thank you, Frank, very much, as always.
All right. Thanks, everybody. Bye.
Great
Thank you.
information. Thank you,
Frank.
everyone, for being here today. Take care, stay safe, get vaccinated.